All right, good afternoon, everybody. Thank you so much for coming. I want to welcome the folks in Rockford. I want to welcome the folks here in Chicago to the electronic discovery program that we have in connection with the 7th Circuit Electronic Discovery Pilot Program Criminal Justice Committee. We've got an excellent program. We have experts from across the country. I know they're probably smiling because they're they're sitting behind me. And but the people that you're going to hear from today really are knowledgeable about the latest activities and trends in electronic discovery. And electronic discovery is never going away. Just like electronic filing, which we converted to about 7 years ago. We are now in the electronic discovery age, and that's not going to change during the time that we, those of us in this room, are practicing law. And so we need to get on top of it, and I appreciate each and every one of you coming here today to get on top of it. I want to do just a quick commercial for the 7th Circuit Electronic Discovery Pilot Program, as well as the 7th Circuit Bar Association in support of it. And if you aren't aware, I want you to be aware that on the website discoverypilot.com, which is a website that was created and established for and by the 7th Circuit Electronic Discovery Pilot Program. On that website, there are a number of webinars for free that we've been putting up and doing over the past several years since the establishment of the 7th Circuit Electronic Discovery Pilot Program. And so if you feel that you are a little uncertain about electronic discovery, you can sit in the quiet of your own office in front of your own computer, and you can get up to speed because we have terrific programs. This program itself will be on the discoverypilot.com as well. I want to do just a quick shout out to person who just walked into the room, Kate Kelly, who has chaired the education subcommittee of the 7th Circuit Electronic Discovery Pilot Program since its inception, along with now Magistrate Judge Mary Rowland. And a number of those webinars, both Kate and Mary were personally involved in organizing and putting together. So I just wanted you to be aware of that. We have, as I mentioned, a terrific program this afternoon, and I'm not going to stand in the way of it any longer. I'm going to turn it over to the folks up here on the bench. And frankly, I have to tell you, it's been kind of fun standing in the well while somebody else is up on the bench. So thank you all for coming, and I know you're going to have a great program this afternoon. So thank you very much. Thank you.
Thanks everyone for joining us this afternoon. We'll start with a couple of introductions. I'm Megan Stack from the U.S. Attorney's Office.
I'm Chris Riddell. I'm with the Antitrust Division of the Department.
My name is Sean Broderick. I work with the Office of Defender Services, and we serve as a resource to both federal defender offices and CJA panel attorneys.
I'm Beth Jantz. I'm with the Federal Defender Program.
A couple of housekeeping items before we begin today. We're happy to share that this program has been approved for an hour and a quarter of general CLE credit. However, in order to get that credit, you have to make sure that you sign in on the sign-in sheets outside and legibly, that is important, legibly include your email address, because at the conclusion of the program, we will be emailing all of you certificates of completion. We're videotaping today, so I just want to note for anybody who's joining us later via video, unfortunately there's not going to be CLE credit for anyone who's not here with us live today. In terms of questions, we're going to ask that you hold your questions to the end, but we have reserved about 20 minutes in order to take questions from the audience. So definitely please jot those down and bring those up at the end of today's presentation. One of our handouts today was a set of ESI protocols in the hallway. Just by a show of hands, how many people are familiar with this document already and have seen it before? Okay, wonderful. For the rest of you, this is a set of recommendations and guidelines that were developed by a joint committee with representatives from both the government and the defense bar to give us some sort of working principles about how to proceed in the area of e-discovery. And some of you may have joined us at our CLE last year where we went through these protocols in detail. But that CLE was really meant to just sort of be conceptual and to get everyone familiar with the principles that are contained in this set of this ESI protocol. We're hoping that today will be a little bit more nuts and bolts and will be a more practical discussion of some of the challenges that both the government and the defense face when it comes to ESI discovery. And so we're hoping that by the end of today, with both sides understanding the challenges that we both face, we'll be able to have more open and cooperative dialogues on these issues in the future. So we're going to sort of go through things chronologically, in effect, and we're going to begin with a discussion of e-discovery issues for the government, and in particular, what types of problems and challenges we face in terms of gathering e-discovery, processing it, and getting it out the door to the defense. And so first, in terms of gathering e-discovery in the first instance, it's important to know that AUSAs need to be really focused on how they go about gathering that information in the first place, because if information comes in the door in a certain format, that may mean that you have limitations later on down the road when it's time to produce it to Defense Counsel. So one thing that we've tried to emphasize repeatedly for AUSAs is that you need to be thinking about e-discovery very early on in your investigation. So at the subpoena stage, when you're sending out subpoena requests to third parties, think about the types of file formats that you should be requesting and the types of file formats that you're going to want to produce in usable form to the defense. Our ALS department is a great resource. They already have established guidelines for certain third-party producers, such as banks and law firms, and they'll be able to help you shape your investigative requests and work with you to make sure that you're getting information in the first instance in the format that we want. For the Defense Counsel present today, I just want to note that it's important for you to know that the government is not always in control of the form of documents we receive. Sometimes the third parties have policies and procedures and they produce documents in a certain way no matter how we request them. Sometimes it is our investigative partners, our agents, who are really the ones liaisoning with these third parties, and so the line assistant who's working on a particular case may or may not have a lot of input or control over the way in which files come in the door. And so as I said, that's important for you to know because the way files come in the door will have certain implications for how they move out the door to the defense later on in the discovery process. And it's not, just subpoenas, I would note. Also think about search warrants. When the government goes to execute a search warrant, particularly when it's going to involve the recovery of electronic information like laptops, we are sort of stuck with what we get. We don't have any control over the evidence we eventually receive as a result of that search warrant. So from the defense perspective, just know that we're doing the best we can to gather this information in a usable, friendly format for you, but there is only so much we can do in certain areas. With respect to then how documents go out the door, in this district, we are typically producing in 3 formats. The main standard are single-page TIFFs that come along with the iPro viewer that allows defense to view the documents through iPro. Occasionally, we will also be producing multi-page PDF images, and then we've been increasingly producing native files. And so Chris from the Antitrust Division is going to walk us through those 3 different categories of e-discovery and talk about how the functionality of each of them differs.
Well, one of the benefits that the U.S. Attorney's Office has with the software that they are currently using, iPro, is the ability to take kind of scanned images and compile them into a viewer as they turn it over to you, which means that you have certain functionality that's already built into the application to be able to look through those documents, be able to search the text if it's available, and kind of be able to see what these documents consist of, how many pages equal a single document, since these are all one-page image files. Along with that, kind of sometimes the U.S. Attorney's Office may provide what we're calling multi-page PDFs, because everyone may have Adobe Reader on your desktop, and so it might be easier for you to take a PDF document. There are some goods and there are some bads, and from a lit support perspective, PDF always makes me cringe a little bit, because there are a million and different ways a PDF can be created, but that affects how a PDF can be viewed. And so it's important that we understand that when we're turning over to you a multi-page PDF, you need to know if it actually has text you can search, or if it's a picture only, and you just have to look at the documents one by one. So while PDF sounds like it's a great thing because you have the viewer, there are limitations to it depending on the size of your collection, and that's one thing I know we're going to be talking about a lot is e-discovery is not a one-size-fits-all kind of answer. You know, it may depend on the type of case that you're working on to determine the type of production you might receive, as much as what Megan was saying, the type we get in may affect how we are able to produce. Another format that Megan had mentioned is getting native files. If we receive perhaps an Excel spreadsheet from a bank of bank transactions, that we might produce then that native file to you so that you have the same functionality that the government had in using that document. If we were to convert that to an image, it would not be useful to you, so that we will then provide it in the native format for that purpose.
And one other point I want to mention for Defense Counsel with respect to our iPro productions is you should know that the first production of each iPro batch that you receive contains on the disk instructions that you can use to help access the documents, to explore some of the different functionality of the iPro program. And I think those instructions may sometimes get lost because you open that disk and there's a whole bunch of gobbledygook and you know to click on the executable file to launch iPro. But just know that on those disks, again, it could be a PDF or a text file of some additional instructions that may help you utilize and sort of sort through the documents that you've been given electronically. In terms, I also want to emphasize for assistance, so we've got various different file formats, right, that the government is currently producing in. And this is a piece of advice that we give repeatedly, and that is the importance of making sure you keep track of what goes out the door to the defense. The days of sort of having your paralegal mindlessly get discovery out the door for you are over. You really need to be an invested and an engaged partner in the discovery process and make sure that you really understand what it is the defense is getting. Now, a counterpoint to that may be it's equally as important to know what came in the door to the U.S. Attorney's Office in the first instance, because again, that may help you work with your team to get the productions together in a helpful and usable format down the road. So to give one very basic example, in a grand jury investigation, you may have a basic log of grand jury subpoenas, for example, and you know on X date you sent X subpoena to a bank for X information and you received back the records on X date. Well, in today's day and age, you may want to add another column to that index which indicates the type of file and the file format that you received back from that producing party. Because again, it just helps keep track of the different types of files we're going to be using. It will help you work with ALS to figure out the best way of getting it out to the defense. Then in the future, so those are the sort of three main types of files that we're working with now. In the future, the U.S. Attorney's Office is going to be moving towards producing load files, and I'll let Chris explain what load files are.
Essentially, one of the goals of a lit support department is to be able to consolidate all the information you have in a particular investigation and produce it out in a kind of a single or stream or format. That makes it a lot easier for us to make sure that we're managing and getting the data out the door, and you as the receiving party have one format to deal with in terms of reviewing, of loading this material into a database. So it's one benefit for us to move from kind of these three hybrid approaches to kind of a consolidated single approach of what we would produce to you. What happens when you receive what we call a load file production is that you get all the pieces you were getting before, but you get a file that wraps them all together when you load them into a particular application or database. For example, I know that Sean has summation as an available tool for your public federal defenders. Sorry.
Exactly.
My shop in the antitrust division, we also use summation. I know concordance is available for the U.S. Attorney's Office. So the idea or goal behind producing these load files is that they're in a generic format that you can take and load into the application that you might use on your side of the house. That you aren't tied to having to use an iPro viewer, you aren't tied to having to use Adobe and its limitations in managing multiple thousands of documents, that this load file format will actually streamline the ability to organize the entire collection of discovery that you might receive. Particularly if it's a rolling production and you're getting it across a period of time, the load files then allow you to kind of consolidate all this information into the application of your choice.
Only thing I will note is that when we eventually move to the production of load files, we're still going to have issues with redacted documents. Right now we don't have a way of including those into the load file. So documents that need redactions are still going to be converted into images so that we can apply the redaction on top of it. And I mention that because that issue may mean that the parties want to engage in a dialogue about expanding protective orders that are applicable to the case that allow the government to forego redactions that they would otherwise be making. Now, it's certainly true that, witness safety issues, issues about ongoing investigations, that kind of thing, those will always be present and unfortunately always require us to redact information. But particularly, for example, in fraud investigations where perhaps you may have redacted personal or confidential type information in the past, it could be that now the parties evolve to a place where they feel like a protective order gives everybody enough protection without the need for those extra redactions. So I just say that as something to consider as we move towards the production of these load files.
And one thing to just comment on the load files is it also means that it could still be a mixed collection of production. You will have images of documents. You may have native files of documents, Excel spreadsheets, or other types of files related to certain audio formats or potentially certain video formats. The idea behind providing it with the load file is that you can at least manage all of that going into an application so that you can search it all, but that it may point out to what those original kind of collection of files are, which kind of goes back to Megan's point of the assistants knowing what you're getting coming in the door will help you even in turning over these load files, because you'll want to point out that certain parts of the collection might be, a WAV file format for audio files, or it might be Excel spreadsheets from certain third parties.
And I also just note for the assistants here today, once we move over to the production of load files, it's going to be even more onerous on ALS. And I will give you fair warning that ALS is going to need even more lead time in order to prepare these productions for the defense. So just know that and make sure that you schedule accordingly in terms of getting organized, getting your discovery from your agents, setting it up to ALS, and make sure that you set the expectations of the defense accordingly. Because when we move over to producing load files, it's going to be next to impossible to get things turned around on a single day basis, for example, whereas given the types of files that we work with today, sometimes that can be a little bit easier.
Well, again, just, as a no one-size-fits-all, if you had a couple of documents, what you might turn over may not be different in the future than what you turn over now. We're talking more of, even when we start to get to a slightly significant collection of documents, you are trying to standardize on the format of production. But again, sometimes what we're doing now might be the only fit.
Right, and that's a fair point. I mean, paper cases are never going to go away, right? We're still going to have our bank robberies, our postal thefts, our illegal reentries, where we don't need to worry about any of these issues, of course. But Chris is absolutely right, that to the extent you start moving into more complex cases, multi-defendant cases, long-term investigations, then that's when these types of issues are going to kick in. All right, moving next in our chronology. So once the government sort of gathers all of its information, gets ready to send it out the door to the defense, the next logical step in the discovery process is a meet and confer with the defense. And this is a relatively new concept that is embodied in these ESI protocols. So we're going to spend some time talking about how that works in reality, what should people talk about, and those kinds of issues.
So the idea of a meet and confer is that you would set aside time, defense counsel and the line AUSA, to talk about the discovery production before it happens. So before you get those disks through your door via email, talk, as a defense counsel, talk to your assistant United States attorney who's on the case, talk about the discovery production. And it should happen before you get anything. And what you should be talking about, we're going to go into this in a little more detail, is the nature, the volume, and the mechanics of that production. And the thing that I like to, I've started doing this and trying to practice what I preach, the thing that I like to look to sort of get me going, what do we talk about, is at the back of that ESI protocol, and there's some hard copies outside, and it's also on fd.org under the litigation support tab. At the end of the ESI National Protocol is a checklist. It's a one-page checklist. There's a lot on there, but it'll get you going, both sides, prosecution and defense, about things you should be talking about at that meet and confer before any production happens. It's an extra step. It takes time. But as we talk about this issue a little bit more, I think you'll see that if you do that work up front, and it can be done over the phone, probably better in person as with anything, but you can do it over the phone. It'll save you time in the long run if you get things straightened out before you start getting those disks and figure out I can't use them or I can't see them. So I turn it over to Chris and Sean to sort of talk about what do you do in the meet and confer, what do you talk about?
Well, and just taking a step back, I think one of the great values of the meet and confer, especially because, let's face it, I see most people out here probably feel the same way as me, is we actually start off with paper. We're comfortable with paper. And we were talking about this today in the Defender office and going through the different ways, and we know how to manage that. And yet we know that there's some advantages, and we know that we're in the digital world. We all got that, we're in the digital world. But what I see taking place, some of the places where the miscommunication plays out, is when there isn't a meet and confer, our conversation to find out, well, what was that original format? Did that come in? And sometimes, you know, I know that on the defense side we think that people might be playing games because they're like, well, why are we getting this format? And I think one of the beauties of this is that you get to go and go, okay, let's take a step back. Let's find out how this originally was produced, because that has a huge effect that we were just talking about. If this was, you know, even though it might have been something that was generated by a computer, and at this point we know that 95% of the information has been generated by a computer at some point, but when a case agent might have obtained it, or when someone else has gone in, before it gets to the U.S. Attorney's Office, it could be in paper, scanned paper, just a, you know, a glorified copy that then what we try to do is we put extra layers on, so it's sort of like those TNT movies. Remember when it was all black and white, and they decided to put the color on top of it? It didn't quite work. Well, it gives us some added functionality, but it's not the same thing as getting a computer-generated version. But I think one of the great things about the meet and confer is the opportunity to talk about something that we never really thought about in the practice of law, which is the form of production, at least in the criminal side. The civil side's been doing it since 2006. So in that, the specifics of going through and thinking about the meet and confer, I think that jump-off point is really valuable, because that then becomes one of the ways you start making decisions about, well, what is a good way to deal with the information. I think there's a number of things to think about, and I'm particularly interested in things that Chris has to say, because she has a lot of experience on these kinds of issues. But I'll say that from a receiving party, which generally defense is in that position, that I think one of the key things is going back and going, okay, we know this case has been indicted or there's a complaint. It's thinking back to, well, what kind of case is this? What is it that generally I would do if I wasn't thinking about paper, when I was just paper? And if anything, I know some people feel that, well, you know, technology, that's behind me. I actually think the people who've been around, who've been doing work, those skills are so much more important because the volume is remarkable. And it's only by keeping those hats on, I mean, litigation support, ALS, fantastic, and yet there's only so much buttons that can be pushed to solve some of these issues. So I think one of the things is thinking about what it is, that kind of case that it is. It's for in the prosecution, most likely it's talking for the key custodians, and that plays out on the defense side. It's often, and I'm going to take an example because it makes it easier because you start thinking of different things. But let's take a fraud case. We'll take a fraud case, 5 defendants. One of the first places to start off with is going to be talking to your client and getting an understanding not only of content but of what data might be out there. What is the data that could be out there that might be coming in? So then you can start making some decisions so you can be prepared for a meet and confer when you can talk to the government and get some sense of what's coming in. It's also taking stock of what technology you have at hand, and that is one of the things that we all know is going to be challenging for everybody involved. The government has been making, DOJ has been making great progress, I know, internally, but still a lot of work, especially compared to what it is in the civil world. Federal defender offices, as you know, that there's a number of tools that now are available. There's some other tools, we'll get in that later, for CJ panel, but what you can handle is a big thing and something to front and have that conversation about so that we can go back around, because often with the complex cases, we're going to have to talk to the court about some funding for some resources in that.
When you think about it from the AUSA side, I mean, my daughter got a fortune cookie that said failing to plan is planning to fail. I mean, pretty hokey, but it's true. You have to take a step back. You want to make sure that you're incorporating your ALS folks, your legal assistants, before your meet and confer, that you understand what it is, the materials you have. You understand the format they came in and the format in which you think you can produce it, even before you go into the official meet and confer with defense counsel. You know, likewise, back that up during the course of your investigation and consider that you might have these mini meet and confers all along the way, from when you first started sending out your subpoenas and you start talking to these banks or phone companies or third parties that of getting material in. That really is kind of a meet and confer. What do they have? How do they have it? What do I want? How do I get it? And so start using that kind of as a stepping stone for you. When you get comfortable with that, that will make the meet and confer post-indictment not quite so scary. The best evidence or the best advice is to know what you have in advance before you sit down, to know what your goods are, what's going to move smoothly through the process, and what your big hiccups are, because you may want to front that is, I've got this, I don't know what we're going to do with it, I'm just telling you that we've got it and you're going to have to deal with it too.
No, I think that's very helpful. And getting into, moving into, like, let's talk about a meet and confer in that process. And I think, Beth, I know that, and Megan, I'm not sure if you've been going through them because it's something that's been happening more frequently. In fact, I know you have been. But I think one of the things, and again, it's particularly important for CJ panel, is getting someone who understands the technology or something about it, be part of that conversation. So that, for example, if you're talking to, so that when you have a meet and confer with the government, and you can have a conversation with someone on their side who understands the technology. And it's okay at this point that people, the attorneys might not understand all the bells and whistles of certain things, but because we're going to get better at it. But for now, having someone who's involved in that, so you can have that frank conversation about, we actually know on our, you know, in the defender office, well, what can we do or not do, or what we have to do with that, and vice versa. And there are going to be problems. And the reality is Chris is absolutely right. There's going to be stuff that's going to come in, and everybody's going, what the heck do we do with this? Just know it exists. There is a lot of great things with technology, but it's causing some headaches. But I think including someone who understands the technology, and then, I think one of the great things about the protocol is that we're all trying for reasonably usable industry standards. One of the challenges I know that exists for everyone is certain proprietary formats, often with audio files. And my understanding is everybody's working on that because that's a limitation for frankly, government agencies at times, because they can't collaborate. I mean, people in the Department of Justice know this better than I do. So I think that aspect, and then thinking about getting a good understanding of volume estimates and sort of the forms of production, especially when it becomes a large one, because, again, you're probably going to have to do a funds request, and you're going to have to know some of that information. And so that if you go back and talk to someone about the technology, if you come back and talk to people in the National Litigation Support Team that are there as a resource, that's the questions we're going to ask you. Because you're like, I don't know, I got a hard drive. I'm like, okay, that's like telling me you got a file cabinet. We have to dig in a little deeper.
Chris, once you feel like the parties have sort of reached a meeting of the minds, at least in an initial meeting, can you talk about how the government might then dip their toe in the pool in terms of getting the production started?
Well, it's certainly important to get, like we had talked about, get your ALS people in place, bring them in early. Even if they're not, if you feel comfortable that you can handle the meet and confer without a technical representative, as Sean suggested, let them know that it's occurring, that it's happening, so that they can make sure that they know what's going to come down the pipeline. I mean, for ALS, a lot of it is it's all getting everyone's work through the funnel and through the pipe, and so knowing kind of timing issues is clearly one that's a criticalness for us. And then highlighting, what is the source and the scope of your production, size and volume, like Sean has been saying, always plays a key role in any sort of discovery that we have. Having an AUSA go into court in front of a judge and says they'll have everything by 5 p.m. tomorrow without having had that conversation with the ALS person in advance, we can't change time or space. We can't make a computer move faster than it actually will spin. So we want to make sure we don't want to put the AUSA in an awkward position, but we just need to have those kind of details in advance. That said, the ALS person can then also highlight for the AUSA when there might be issues or problems, or it might take more time than we had anticipated because they're shutting down the power in the building for the weekend and we can't get something done. So there's a lot of real communication issues, communication that has to occur among all members of the team.
And can you talk about the concept of potentially doing a sample production?
Absolutely. One of the things that I find in our antitrust division, both on our criminal and on our civil side, is that we deal with large scopes of data. And in talking with parties about what we're turning over or what we're having turned over to us, I don't want 4 hard drives of data if I haven't had a sample of at least 100 or 200 some records first to make sure that the format that we agreed upon, that we talked about, we're able to take and we're able to load and use in our applications. And likewise for Sean, that anything that we would provide to you would be you could take and you could use. And so if you start small and start with a sample production, that may cross the different types of information or files that you are producing. That sample, taking a little time to look at it, go back and forth if there are problems, and then move into your larger production is ultimately going to save time on both sides. And by working through that, you've solidified really the benefits of your meet and confer, that you actually are working together to resolve these issues, and these issues aren't what becomes what the trial is about.
And to follow up on that point, so, and I'm guilty of this as much as anyone. I get those discs in the door and I shove them to the side of my desk, or I put them in a file. And to follow up on that, when you get the sample or when you get the whole production, just open it and make sure you can view it. Even if you don't start your review right then, I know it's hard. I've been trying to do it myself, but really it will save you time down the road when you do sit down to have that review. And second, and probably more importantly, for the defense, send that stuff to your clients and see if they can see it. Because particularly for folks who are incarcerated, these are hard issues. We don't have the answers up here today, but it's better to find out early in a case that your client can't see that at the jail, or even if they're out on bond, and have a discussion about that. We don't have answers for that, but it's something that's going to have to be addressed in every case. And it's better to do that early, before the government has done its whole production, when you can try to work out those issues. So I'd encourage the defense, as much as the onus is on the government, so is it on the defense, to look at that stuff early, make sure it works for you and for your client, and then you can move forward from there.
We certainly all have resource limitations, so.
Right, and the government is just as invested in making sure the defense has a usable product as you are. So if you get a disc and you're not able to open it, I am happy to help you figure out the problem. All of our assistants are, because we know that if we don't help you, your next complaint may be to the judge, and that's an uncomfortable place to be. So if you find that you receive, especially electronic discovery, and you're having difficulty either opening it or using it, your first call should be to the line assistant on your case. That line assistant may or may not have the technical skills to be able to actually help you work through the problem, but they certainly know who to refer you to in-house in our office. And sometimes it may be a matter of just there's different steps for Mac computers, or you need to be told you can't use a Mac computer. And sometimes you help us discover that there are more significant problems with the production, that it needs to be redone, or we need to take a closer look at something. That's very much, it should be very much a dialogue between us both. So just know that we don't expect defense counsel to be sort of muddying along and figuring this out on your own. We are here to help you with those problems.
One of the other things about the meet and confer, and that about the ESI protocol that is strongly encouraged, is the exchange of an indice or a table of contents, so that you can start having a more meaningful discussion as opposed to just plopping down a hard drive on someone's desk and say go. It shouldn't, if you've been kind of managing your case all along, or starting from the beginning with like the subpoena log that Megan was talking about, be too difficult to create this kind of high level. We're not talking detailed file by file, but more of a general overview sense of what is contained in the discovery that you have, so that you're both having a conversation where you're both understanding what is contained inside this discovery. So those type of that type of document is certainly helpful, and it's helpful on both sides. And if you're preparing for it accurately, it's not going to be an additional burden for you at time of indictment. It's something that you should kind of have all along the way, so that you're managing your case, and then it's just a matter of tweaking a little bit and making sure, and then turning it over.
And let me just say that there's certainly no one-size-fits-all when it comes to table of contents, indices, and that kind of thing as it relates to discovery. Obviously, it's going to be a case-by-case basis. The one thing I will say to the assistants, though, is I think the case law is leaning towards, if you're doing a significant production, you've got to give them something. And again, the level of detail may vary depending on your case, but it is no longer okay to just send over a cover letter that says, here's a disc. You've got to give them some tools to be able to sort through the materials that you've given them. And again, I think, and maybe Beth can talk about how that will better position both the government and the defense to the extent that any of these discovery issues rise to the level of needing to go to the court.
Well, like with anything, if you can go in front of a judge and both sides can say, we've been working on this, here's the things we've been talking about, here's the things we're waiting on, the judges are going to be more likely to give you time, of course, to work on those things. So I think an additional benefit of the meet and confer is that you can cite to the judge the concrete work you've been doing to try to put both sides in a position to move forward. And I think that that's going to enable both sides to get the time we need to work adequately on our cases.
Yeah, and one other thing, doesn't happen, I mean, a lot depends on the specifics, but I will say there has been times where actually in the meet and confer is that you can even have a conversation about even some cost sharing. It doesn't happen that often, but I'm actually in the Northern District of California, and we've had a number of cases where something has come in, and it was 30 banker boxes, and was able to have a conversation of like, okay, CJ panel, they wanted in multi-page PDFs. The government wanted it in single-page TIFFs. In that instance, actually, I was with the defender office. We wanted single-page TIFFs. So we were able to get it done cheaper, and split the cost and get it in formats that were helpful. Again, that's a very, most of the time it's already come in, but that is something to consider when you get into some of the challenges, and I've known in other districts people have explored cost sharing when it's like, okay, maybe some of this basic work that's really just sort of automated can be sent somewhere out. So it's something to consider.
And Sean, that reminds me also, the meet and confer may also be the time when the parties want to bring in one of the coordinating discovery attorneys. Is that right?
Yes.
Could you talk about that?
Yeah, no, I'm happy to. Thank you for reminding about that. So, right now, we have nationally available 4 CJ panel attorneys in the FDOs. There are 3 people who are on contract who have an expertise working with electronic discovery. And they've been appointed in various districts throughout the United States and pretty much many of the circuits. And what is helpful is for in complex multi-defendant cases, they can do some of the front-end work on the defense side, help with the meet and confer, and have a conversation with AUSAs, and they understand some of the challenges that are involved. And they can then help sort of manage some of those kind of issues, help to get defense counsel to know what it is that they might be wanting or to articulate what it is that they're looking for. And it is something that is available, and it's been working out well, because in some of these instances where there's just, again, some objective information that's useful for defense counsel, they can get it organized, they can do some of the prep work, and allows CJA counsel to frankly focus on their clients and focus on the specific needs of that client and not being worrying about, being a litigation support person.
And from our perspective, and I typically deal with a lot of volume of data, but overall, with this meet and confer and with kind of sharing the indice of what you have, helps kind of prioritize the discovery only in the manner of what do we need to turn over in what format or in what order. There might be things that might be more relevant to start settling out the case, or at least bringing issues up to the front, and having that kind of table of contents can maybe get you towards that part of your case quicker, as opposed to producing or turning over everything all at once, which puts a strain on your both sides of resources, and just kind of helps move the case along a little bit.
Okay, once the parties have accomplished a meet and confer, the next logical step in the discovery process is for the government to actually push the discovery out to defense, and then the question becomes, what does defense do with it? So let's hear from Beth and Sean.
And Sean referenced this a little bit earlier. I think the first step for defense counsel in thinking about discovery review is what kind of case is in front of me. Our legal reentry cases, our bank robberies, even those are going to get a little more technical, but we're talking about the ones that scare me a little are the big fraud cases, the ones where I can see and I anticipate I'm going to be getting a lot of discovery, and it might be in different formats. And how am I going to go through all this? I'm one person. Resources are limited for everyone. How am I going to go through all of it, figure out the important documents, talk to my client about it? So how do I get that going? The first step, I think, is the meet and confer. And I've been trying to start this myself and making myself do it. I had an ERISA fraud case, and I thought, okay, I should sit down with the checklist and go through it. And hopefully, for both sides, government and defense, that will pay off in the long run. I think most issues we're going to be able to work out in most cases. Even if you can't, at least both parties know where they stand, and they can go with to the judge with very selective issues. And I think judges are going to be more receptive to that when you're not just throwing everything at them, but saying, we tried to work this out, here's the one issue we're stuck on, can you decide that for us? So I think that's the first step, and we've talked a lot about that. The next step is once you get that discovery production, once that's going, I like to start with the indices or the table of contents that you get from the government. I've been getting these in most of my cases, and they're really good and they're really helpful. And so if you're not getting those as defense counsel, I usually just ask, and it's readily provided to me. I've had really good experience with it. They come with Bates numbers and descriptions, and that really gets me going. Just asking your counterpart, AUSA, what do you think are the important documents? And sometimes you can have the discussion and sometimes you can't, but when you can, that gets you going. Obviously, as defense counsel, we need to go beyond that, of course, but that really that's a place to start in your review process. We talked about this a little bit. Make sure when you get those discs, you can open them and you can view them and you can handle them, and so can your clients, or else your review's not going to go anyplace. The next thing I like to do is I try to take, if I've gotten different disks or I get things via email, put them on one folder on my hard drive. It seems simple. I didn't know to do it until Sean told me to do it. But it's really helpful because you preserve the original production. It's in your email or it's on a disk, but you put them all in one place so you know when you're reviewing, I didn't miss anything. And we're going to be talking a little bit about software tools that are available for review. If you do coding work, you save it there all in one place too. So it's a small thing. It's really helped me a lot. Just put all the discovery together, one folder on your hard drive or a shared drive in our office. And so that gets us to, okay, you've looked at sort of the hot documents, you've gone through the table of contents, you've got all your discovery together. Now for the more complicated ESI, what kind of software tools are available to the defense that will help us? You know, there's 10,000 pages or 20,000, we cannot look at them all. So what kind of software tools can help us drill down and look at the important issues in the case? So I'll turn it over to Sean to talk about that and some other related issues for the defense.
So this is a tough one. But there is a number of different tools out there. We try to provide, we serve as a resource for various people in defender offices. And the reality is that a lot of the really high-end stuff, like you're dealing with antitrust, you're going to have to you're not going to buy that off the shelf. It's going to take some time. That said, there are a number of things that are available. We have a search and retrieval tool that's free for CJ panel attorneys, basic search and retrieval, but you can do some pretty good searching and some more conceptual searching. It's a program called ISIS, and that's available for the CJ panel. The information for all this is on fd.org.
Could you just really explain what conceptual searching is?
Conceptual searching. Okay. Chris, what's conceptual searching? Well, actually, I meant to say Boolean. If I said conceptual, I should have said Boolean, but
Keyword searching.
keyword searching, yes. It really is sort of keyword searching. Thank you. But the idea of conceptual searching is a more advanced ESI analytics that are out there for the very large cases where you probably people have heard the term predictive coding. It's like sort of the hot words and stuff. But it's very cool technology. It costs a lot of money. Shortly, the short version, there's different ways to play it out, but the nice thing about predictive coding is that if you got a document and you can start feeding it into a system, and you can give them 50 documents, then it'll start looking through the data, say, here are similar documents like this, and you can start reviewing it, a combination of using technology and legal skills. I'm using a broad stroke to all this.
A concept search and a basic example that a lot of vendors use is I have a collection of documents and I type in the word Thanksgiving. And the search in the software is going to retrieve for me documents that have the word Thanksgiving in it, but it's also going to retrieve documents that talk about football and talk about apple pie or pumpkin pie or Black Friday or things that, documents that don't have the word Thanksgiving in them, but that combined with all that other information pulls together you a pool of documents that's about the concept of Thanksgiving, even though that word is not there. Keyword searching is word for word searching. Concept searching is grouping together similar ideas together based on the words that are in these documents. And then predictive coding takes that an additional step further and allows you to train the system to go find the documents that you want and consider the most relevant of a collection.
Yeah. So ISIS is really for keyword searching, but it's a good tool and it's free. Also have reduced rates for a program called Case Map, which many of you probably have heard or used. Department of Justice has had an enterprise license for it for ages, and that's a good tool in particular because it was designed by attorneys thinking about legal issues, and it's set up in that kind of way, and it works very well with Acrobat PDF files, and it has now some additional capabilities to deal with some non-native PDF files, some more of the ESI kinds of things, but it's a good tool that's also got a reduced rate. And then Trial Director, which is a presentation software. The government uses sanctioned, they're very similar programs, but excellent tool for presentation in the courtroom if people, for when you go to trial. And then lastly, we do have some space available through a web-hosted service called CaseVantage with a company called Access Data. And if you have a very large case that you think that might be something of interest to you, if you're in the CJA panel, feel free to give us a call. Again, all of our contact information is on fd.org. So it's, you should be able to track us down.
Sean, can you give especially panel attorneys any advice about the types of technology they should be thinking about purchasing in the future to help aid their e-discovery review in particular?
Yes, it's not an easy answer, to be honest with you. I will say this. One is right now most of litigation support technology is Windows-based, so it's challenging for those who, I have a Mac at home, I love my Mac, I love my iPad, but some of the things we're looking at is going to be PC-based. I think the market is starting to adjust to the realities that ESI is hitting everybody. It's not just the large companies and stuff like that. At this point, we're happy to talk to people about their case and walk through some of the options with it. But at this point, I can't say like you should buy X software, because at this point it is a fast-moving industry, and the industry really is moving towards web-hosted solutions, which makes it particularly challenging when you've got you're dealing with data, or you're dealing with data when clients are in custody, and that is not necessarily going to be an easy solution.
And I think, Sean and Beth, you guys have some tools in the form of maybe some upcoming seminars and stuff that especially panel attorneys might be able to take advantage of in terms of how to use the different tools that Sean just described.
Well, I think the thing I'd encourage everyone to do on the defense side is go to fd.org, particularly panel attorneys. Obviously, in our office, we have more internal resources, but panel attorneys, go to fd.org. There's a litigation support tab. It has tons of information, just really good stuff. And when seminars are planned, then it would be on there as well. Some of the software products' own websites, they may be offering webinars or tutorials, because frankly they want you to use and buy this stuff, so it's probably in their interest. And I think about it in terms of moving from like the law books to Westlaw or Lexis. It's hard. It's not easy to learn. It's not I wasn't taught e-discovery in law school, and I'm trying to learn these software products, and it's hard. But I think it's increasingly becoming necessary for our practices, but more than that, it's pretty amazing when you learn the tools how much you can search and filter and the things you can do that you couldn't do before. And that's going to benefit, I think, hopefully both sides. So go to fd.org, there's some information there, but it's going to be a new frontier that we all need to learn together. I wish it were easy. I don't think it's going to be, but we'll work along on it.
And our goal is, we also do have a blog that's linked to that, and there's actually even a couple sort of short videos that have been done to walk through some basic processes as something to consider. We have a couple of national trainings that we're doing in July focusing on trial presentation, and in September focusing on what we call techniques in electronic case management, which focuses on Acrobat Pro, ISIS, and CaseMap. And we keep looking to getting feedback for things that people are interested in, and look to add some additional training along those lines. So it's definitely a collaborative process.
I think one of the key takeaways here is that it's a little bit of a bumpy ride. There's a learning curve for everybody, and the fact that the learning curve doesn't really kind of come back down. It's still going to go up at a high trajectory because there are new tools available on the marketplace all the time. We were talking about predictive coding or assisted review. Those are pretty new concepts. I mean, for the legal environment. I mean, that type of work might have been done, by behind closed doors, black ops, CIA kind of stuff. It's frankly where we get a lot of our technology from the defense side of defense industry. And it's now becoming available to us. And how do we manage documents? And how do we search documents? And how do we search audio? So it's not to say that we're all learning. And as much experience as that any one of us might have, there's something that's coming available or a new technology that's happening tomorrow that we don't know about either. And so we're trying to keep ourselves open and available and learning for what the next thing is, because we might have a file format that we've never seen before, and so we have to figure out a way to handle it. So we're going to go and look for a tool to use it. And so for everyone kind of in this process, whether you're a novice at this or you've been doing a large-scale discovery for a number of years, there's always something new to learn. There's always something that you didn't know, or you thought, oh, if I had known that last case, it really would have helped me out. But take that and apply it future forward, and the ride will smooth out for you until the next new thing happens.
Comments from the defense?
I mean, I guess the only other thing I would say would be that I would encourage, if you're on the defense side and things come up, I would encourage you to ask and to talk about it and say, these are the things that I'm having challenges with. I mean, I think if one is dealing with a hard drive, having an exhaustive, detailed index is not going to be reasonable, and no one's going to do that. That said, I think that if you say, look, I have this specific issue, I need to find out this information. I know of a case where they were dealing with wiretaps, and they were able to say, look, we don't know the context for this. Went back, had a conversation. In that instance, they were able to work it out and get certain information from the case agent. Is that going to happen all the time? No, but you've got to ask. And it's important to explain why and be reasonable about going, we understand the things about that. But it can help you in the long run and be able to, so both sides can deal with the challenges that they have.
I think you're seeing with the courts that, not saying that you don't understand or you don't know about ESI isn't going to fly. You have to make sure that if you don't understand the problems with the ESI or the electronic stored information that you are getting, just saying I don't know isn't going to get you anywhere on either side. That you have to invest a little bit in yourself, and you have to invest in what your office might know in order to learn about this and bring forward what it is you don't know, so that you can kind of resolve the issues as quickly as possible.
Well, lest this all seem overwhelming, Beth and I wanted to spend a couple of minutes focusing on some progress that we actually have made in this district regarding e-discovery, almost in spite of ourselves and perhaps without labeling it as such. But Beth, can you talk about some of those things?
Well, so I'll cover sort of, when we touched on this briefly, indices and table of contents. I've really had a great experience over the last year or two of getting those in most of my cases. When I don't get them, I ask for them, and they're readily provided, and they're really helpful to me. And I don't have to learn a software tool or anything, just to ask for them and to see what's on the disks that I've gotten. It's pretty easy, and I think it's really, really helpful. So I'd encourage everyone on the defense side to ask for those if you're not getting them. I've had a great experience. And just to follow up on Sean's comment, similarly, if I'm having an issue, I go back and I ask questions, and I've had a good experience working with line ASAs to work out these issues. We're not always going to agree. That's okay. We can take selective issues to judges when we need to, but I think in most cases we can get farther ahead if we talk about these things and identify the problems on both sides.
And I'd also just point out that I think generally speaking, of course, I'm sure there's an exception here and there, but generally speaking in this district, I think the government's production of audio and video files, including wiretaps and line sheets and that sort of thing, which is e-discovery, has been going pretty smoothly, I think we'd all like to think. I think the government has understood how to produce that in a usable format. I think the defense bar has gotten used to the tools that we use with our investigative partners, is learned how to open those types of recordings, how to search those line sheets, and that sort of thing. So again, that may not be an obvious example of e-discovery, but I think we've arrived at that state in this district in large part because we're having those conversations that Beth and Sean keep talking about, and when there are problems, I'd like to think that for the most part, you have a receptive ear from the government in working through those issues. So I say that because I think we'd all like to think that that is sort of a a prediction of where we may be in 5 years from now, where this all seems a little overwhelming at this point, but if we can work together, we may find ourselves in 5 years where load files and working with summation is sort of is old hat for everyone. So with that being said, does anybody have any closing thoughts before we move to questions? Okay. All right. Now it is your turn. So we really do encourage questions. If any of you have anything you'd like to address with the panel. Yes.
It would actually be a mix. I'm sorry. Just to repeat the question, was that we've been talking about the local district here going to load file format for production, and does that mean receiving native files? And the answer is kind of yes, but it depends on what we got in the first place. I mean, it may be we took paper and we scanned it to image, and we're producing that to you, the images instead of the physical boxes. The load files that you would receive, the question was, would you be able to put that into your software? The idea is that the load files themselves are in a generic format that with a little tweak, depending on what your application is, you would be able to load this in.
In the somewhat near future. We're working on it. Yes.
Well, as generic, does generic mean Mac? And we were having this discussion actually a little bit earlier, and to kind of focus on what Sean said, a majority of the lit support applications that are available on the market are Windows-based. And so we're dealing with the load files will go into whatever application might be on the market. I can't say that Apple's writing one or someone's writing one to store on a Mac. But that's where the industry tends to be going to this more of a hosted solution, or if you want to use the word cloud, you can, where your information is stored on a server somewhere and you're accessing it through a PC or through a Mac, but there's really nothing on the Mac itself that needs to be installed.
I mean, I think, unfortunately, there just isn't those applications on Mac. I wish they were. But Chris is exactly right. I think the way the industry is going, web-hosted, I think might reduce those challenges. But it's not going to happen right now.
Fine.
What's the current status of iPro, its search capacity, being able to search everything you're giving us in iPro?
So the question is, what is the search capability of iPro? And I can give you a brief answer, and then perhaps Chris can expand on it. I think in part the searchability of iPro depends on the quality of the documents that are the quality of the images that are loaded into it. And so, for example, if you have a fax that has been copied 3 times and is loaded into iPro, the OCR capability to read that is not going to be as great as if you had the original document in electronic format and loaded it into iPro.
I think that's absolutely right. I think what we're talking about, the iPro viewer, a lot of what you've seen so far are scanned paper documents where the OCR process has been run on top of it to convert that picture into text. And the text is always only going to be as good as the original picture was. Now, when you switch to getting email or getting any other electronic file available, you still have an issue in searchability in that it's only as good as people can spell. You know, it's only as good as as how people use slang and dialect. And so you have to kind of adjust your searching to the collection that you might have in front of you.
And to follow up on that point, I mean, you know, iPro admittedly is not a perfect product. And so I think that's where the combination of the searchability of your production along with an index or a table of contents from your assistant should hopefully do most of the work in getting the defense where they need to go. But for example, this is part of the importance of this dialogue that we've been talking about. I think assistants are sometimes under the impression that if it's in iPro, it's 100% searchable. And for the reasons that we're talking about, that may not be the case. But we may not figure that out until it's brought to our attention by defense counsel, in which case maybe we make adjustments, maybe we do a more extended index, you know, that kind of thing. We sort of work together to figure out how to solve the problem. But like I said, we may not know that that's a problem until you call it to our attention. And if you're willing to do that, we're willing to work with you.
And to add to that, client's ability to look at stuff, particularly clients who are in jail. Yep.
Oh, absolutely. I mean, if you look at the protocol, that's principle 10. That's one of the things that's very significant. The challenge is that, so yes, absolutely, that is very much the forefront of, I'm sure all of us, that is one of the things I think a lot about. And I will say that we should, this is one where it's really being thoughtful of what information is being put up there. You got to think about, think about the level of risk. There's certain things that there's no way ever. There's a gradation of those things that take place. And I will say that the industry has moved that way. That's why, how many of you use online banking? We all use online banking, which doesn't mean we shouldn't be careful. Far from it. You're absolutely right. I think it's an important issue. And yet there are, infrastructures and there are ways to make these things work.
And the only thing I'd add to that is I think in this district, our next big frontier is moving towards the production of load files. Beyond that, I would say, is the use of these web-based discovery programs, and that is way far in the future, and it may be that we never get there on a global basis. It's only very specific, very large, very complex cases are hosted on those web servers. So in terms of ubiquitous use of web hosting in this district, I don't see that happening in the near future.
The receipt, if you getting the load files, though, if you are on the defense side, allows you to load it into whatever other application you choose to use. But you do have to keep in mind those security requirements or protective orders depending on where you put it. Don't put it on Google.
Yes, Cindy.
I too start out thanking you for the index and the table of contents. It's nice to get your opinion about those. I'm wondering if when your office does everyone have their own format? I mean, some seem more detailed than others. I guess my question would be, does anyone ever, for example, I go to GJ, or grand jury first. I'd like to see what people say rather than what the Bank of America records say. Does anyone index them with the witness names, or are they right now just being indexed as grand jury? Is there a way to get an index on grand jury and reports that you're already doing? I'm not asking you to do it. Is someone already doing for your office the names of the witnesses in the report so that I know to go? I mean, sometimes I get that. Sometimes I get a very detailed, here's, but not. I'm just wondering how you're doing it.
Right.
And if there's a way that you're already doing it that we can plug into to make sure that we're getting the best index possible.
So the question is whether or not there's any sort of office-wide policy in terms of the content or the comprehensiveness of indexes that accompany discovery. And the short answer to that is no. I think you won't be surprised to hear that it's very difficult for us to develop any kind of office-wide policy on that because it just depends so much on the particular facts of each case. And each case is going to vary, not just number of defendants or the type of evidence, but also where the government gathers all of its various information or reports from. And so we have not imposed any kind of office-wide requirement on the assistants. We have, however, said, as I've said repeatedly today, that you've got to do something. And the one thing I would suggest to the assistants is to the extent that you are doing some of your own internal indexing, it is almost always going to be helpful to share that with the defense, of course, scrubbing out any potentially work product information. But to the extent you find it helpful to have organized your documents in a particular way or to have created those types of indexes, if the defense indicates that that would be helpful for them, then share it, because it's going to get everybody moving down the same path at the same time, which is ultimately better for the resolution of your case. And I think of that in sort of a related concept to something that is in the ESI protocol, which says for the producing party, who's typically the government, if you process e-discovery in a way to make it more helpful to you, then you should share the results of that processing with the defense. But what it also says is that if we don't do that processing, then we're not under some extra burden to do it just because you've asked. So similarly, with respect to indexes, if assistants have taken upon themselves to create certain indices of discovery, I think similar principles should apply. We should just share those with you because it's more helpful to the dialogue. And if we haven't done it, then, you know, we may maybe have a dispute about whether or not we need to create something that doesn't already exist. But so that is the sort of, I think, path we should be on in terms of indices and tables of contents. And in terms of people in Rockford, if you guys have any questions, I think you just need to unmute your microphone, but feel free to jump in at any point.
Thanks, Mike.
No problem. Yes.
Is there going to be any availability to get away from the DVD format, maybe like a thumb drive from the U.S. Attorney's Office or a hard drive of some sort?
The problem is for thumb drives and hard drives, we have to encrypt them. Is that correct? And that causes a lot of problems in terms of your ability to access them and that sort of thing. So in terms of our internal guidelines about how we produce things, right now, DVDs and the like are just easier. If you have a case that has a huge volume of stuff, occasionally we work with Defense Counsel where you provide us a hard drive, for example, that we may populate with information. Again, I think that's relatively rare and that's really intended for enormous cases. Is that fair to say, Linda? Okay. So, sorry. The short answer is probably not right now. Other questions? Anybody in Rockford? No. Oh, yep. I'm sorry, Mary, could you repeat that question one more time?
You mentioned earlier today that days of just giving us a disc and saying, here's a disc, here's discovery, are over. And I'm just wondering, we used to get, before this, we would get pretty detailed, like you have base stamps 1 through 60, or, you know, all the different breakdowns. Is there any way to include, in addition to maybe base stamp numbers or something, what the format of the disc is, or something that would help us, like, immediately with regard to what the discovery is? Because the first thing, like, our office is all asking us is what the format is, and so I just wondered if that's not familiar, if that's too late or not.
I think, well, at least you should know, to the extent you're getting a disc that has recordings on it versus a disc that has reports or some other type of e-discovery. I think you should at least know that. So you should be able to tell, well, this is either a disc of reports or a disc of recordings. I think we're at least doing that minimal level of distinction. Beyond that, I think, to be honest, that is something new that we're struggling with. And like I talked about today, this whole accounting for formatting is new, very much new to the government as well. And it was never part of our policy in the past to know, okay, well, this disk has PST email files on it, and it has Word documents that we got natively, and it has scanned PDFs. I mean, we just never have done that. I think that, you know, the new frontier that we've been talking about today is that we're moving towards needing to account for all of that stuff. But I think your question is sort of a jump off from Cindy's, which is, it's a question of the level of detail that we provide to you with the discovery initially, and that is sort of A, a work in progress, and B, I think varies throughout the office depending on the nature of the case. So, Steve. Steve.
I want to underscore the point, Cindy, about getting indexes that have names attached to the MOIs to the grand jury. And it seems to me the easy way to solve this is for an office that has rules about everything. There could be a rule that that's what the assistants are supposed to do, except in some unusual, extraordinary circumstances, and then we don't get them.
Well, Steve, I think what's hard about it from our perspective, and we don't have rules about everything, most things, but not everything, and this is a perfect example. What's hard about that is we don't necessarily know what's in your head, right? And so we could index something as the grand jury statement of Steve Saltzman, but the reason that may be important is because of what Steve Saltzman says about Megan Stack in the testimony. And if all you get is an index that says grand jury testimony of Steve Saltzman, it's not necessarily going to alert the reader that the importance of it is that I'm mentioned in it.
It's a significant start over what we've at least gotten in the past.
Agreed. And a lot of times it's a function of We have some agents who are wonderful at organizing and labeling discovery, and we have other agents who e-discovery, if it's new to us, it's brand new to them, right? And we have some paralegals who are wonderful at helping us navigate these things. We have others who are overtaxed and don't have a lot of time to help in terms of that indexing. So from the government's perspective, I would say, look, we get it. We understand that it's enormously helpful, and we're trying. We're just asking you to recognize that we are sometimes sort of suffering under a mountain of stuff, and we're doing our best to get it out to you quickly in a manner that you can use and open, and then also to give you tools to be able to sort through it. So again, if you kind of help us, you know, sort of figure out what you're looking for, pick up the phone, and we can work together. And I hate to say that it depends to all these questions because I know that's not that helpful, but the answer in terms of the level of comprehension for each of these indexes really is just going to depend. Other questions? Anyone? Don't be shy. Yes.
I figured a couple of weekend side reports. It's like in math class. The problems are so complex, it's hard to direct it to what's shown at the seminar. But I thought I had it all figured out, so I have 15 minutes. And it just gets more and more involved. What I'm getting to is, Steve was suggesting a protocol of some sort. Is there some way that you, Sean, and put out a protocol for how to deal with just like simple things like documents, not Excel sheet, just documents, and you copy them onto the clean slate, and then you play with the other ones, Adobe. Even though I've taken that, it's still like overwhelming. And I don't know where to begin in terms of once I've got them copied, I don't know where to begin trying to break down trying to organize into basic things like grand jury and the next logical step. What I'm trying to get to is there a way that we today can be given an overview, like a protocol, I think I can think of one thing to think of, from your office, which allows everybody dealing only with documents, is somewhere like more than 100,000 pages. Is there a way that we can, is there something you can suggest, other than reading SAP.org?
Right.
Is there something you can suggest that would allow someone trying to stumble through all of these documents to break them down into views so that we can get some sort of organization other than just, maybe this is a better articulation. Is there some particular program that can take all of these documents and generically base them so that we can search that one particular document, search that one mass of data with one particular program? Is there something like it? Yeah.
Well, I will say, and we can definitely let's talk more offline about things because I know you've been going to programs. We've been working on those things, and it is challenging, and so much depends on the context. So I'd love to talk further about that. And I'll say that one of the things, and that's helpful about the protocol, is to move to one, make sure things are searchable, moving to things that have more searchability, and then thinking through of how to do some of that search, but taking the first step of going, what is it I care about in this case and what I need to do? What is my end goal, and working backwards? And I think part of what we probably need to do is come up with more vignettes, specific framework, and saying, here is this scenario, and walk on that through. So let's talk a little bit more about that off camera. But I don't know if there's other things, Beth, that because you're someone who's in a similarly situated situation, or if there's anything else that I should be saying.
Well, I think the short answer is no. I wish there was a program for me, I wish there was a program where I could just put all my discs in and I could look at everything and search everything. I don't think there is that one answer, and so I think trying to go to the trainings and doing webinars and reading literature and just playing with the programs themselves, like with anything, I think we get better when we do it. It's hard work. I think that's probably the only way. I don't think there's one program, one answer here, but we will get better because you do when you work on this stuff.
And I will say, it's the part of the problem is this is really actually interconnected. It is what your all's legal acumen, the things that you bring to a case, knowing how to use some of the parts of technology, but then it's sort of an iterative, a repeats process. Search and retrieval is really a repeat process. And so we'll keep working on that. But I think as we get more comfortable, it will be a little bit easier to sort of understand that, have better conversations with all parties about what form that is, and it's going to get a little bit easier, but it's going to be tough for a while. I'm sorry.
Other questions? Okay, just a couple closing comments. Oh, yep, Chuck.
The question came up about web-based. You just take, at that point, you take all the documents, no matter what format they're in, and send them up as documents, and then you can download into whatever format you want, as opposed to sending up iPro. You then have to do iPro up in the
Cloud.
Well, I think, in terms of where we were talking about the load files and the fact that the load files are created to go into a variety of applications, that the load files, again, are just a wrapper around what the evidence is. And the evidence might be an image format, it might be in a native form, an Excel format, it might be in an audio format. So the load files just kind of tie some information about the document, like a Bates number, to the file itself, regardless of where you're going to put it. If you're going to put it in an application that's stored, that's a web-hosted solution, or one that's stored on the hard drive of your PC.
Well, and I think partly what maybe where you're getting at, and I think we're going to get there at some point, is sort of an FTP site. And maybe you could describe what an FTP site people are, but that might be where that replaces some of a way, instead of having to put everything on a CD-ROM, it's a way to transfer information from one party to the other.
Right, and what that is essentially is, instead of creating a physical piece of media like a DVD like we were talking about before, is basically uploading or putting it in a secure location where then you can log in and download it onto your machine. There are secure sites to do that. The department uses a particular one called MyFX. It has certain limitations on the amount of files that you can put up, the size of files. And so I don't know that even the department, regardless of component, whether it's U.S. attorneys or antitrust or any other component, has a clear policy as to when we upload, and as opposed to physically providing a piece of media.
Was that along the lines that you were thinking about, or did I?
Well, the question was, that we were talking about was, for example, iPro. Would the sub be still iPro, or would it working out iPro?
With the movement towards the load file format, it's broken out of iPro. If you choose to go then and load it into iPro, because that's the tool you have, these files would work. If you would prefer to load it into concordance or relativity or summation or case map, another lit support application, these load files, with a slight adjustment depending on the application you're loading into, should work. They would load in. And basically what it gives you is a list of the production and your ability to access the files.
Anything else? Okay, thanks again for joining us today. Reminder, please sign legibly on the CLE forms. Please also fill out those evaluations and leave them in the hallway. They're very helpful for us.
And there's snacks and drinks, hopefully, if they were delivered, down the hallway that way, so feel free to take some. Hopefully they're there.
Thank you.
Thank you.